So, when you think about the US Supreme Court, what words come to mind? Probably things like justice, law, maybe precedent. I bet lawless or bad vibes aren't high on that list. But what if they should be? We're about to dive into a really fascinating and pretty provocative critique of how the nation's highest court is operating right now, all based on the work of law professor Leah Litman. And just look at the subtitle of her book, How the Supreme Court Runs on Conservative Grievance, Fringe Theories, and Bad Vibes. Right off the bat, you know this is not going to be your standard dry-as-dust legal textbook. This is a bold claim about what's really motivating the court's decisions. I mean, it's a phrase that really grabs you, right? Bad vibes. But what does that actually mean in a legal context? How can the highest court in the land run on something so subjective? Well, that's the big question we're going to unpack today. Okay, so to really get what Litman is arguing, we first have to define her terms. We need to break down these three core ideas she lays out: the grievance, the theories, and of course, the vibes. First up, the vibes. We usually think of the law as this objective thing, kind of black and white, with clear answers you can find if you just look hard enough. But Litman argues that's not what's happening. She says the court is increasingly relying on subjective feelings, these vibes, basically writing their own personal policy preferences into the law that affects every single one of us. Next up, fringe theories. What Litman means by this is that the court is reaching for legal arguments and ideas that are, well, on the fringe. They're viewpoints that aren't widely accepted or held, even in conservative legal circles sometimes. But the court is picking them up and using them to justify its decisions, effectively turning a minority view into the law of the land. And finally, conservative grievance. Now, this is the one that Litman suggests is really, really strange. Her argument is that the court seems to be operating from this worldview where some of the most powerful people in groups in society, we're talking the super rich, big corporations, certain religious groups, are actually the ones who are being oppressed and need the court's protection. And to make this concrete, she points directly at campaign finance cases. Think about it. The court has repeatedly struck down laws that try to limit how much money can be spent in politics. And the reasoning can sometimes sound like the system is being unfair to billionaires. The idea that someone with immense wealth is a victim because democracy prevents them from using that wealth to dominate the conversation, Litman says that should be a real wake-up call.
Okay, so to really understand the legal machinery that Litman says is powering all of this, we've got to take a quick step back and look at a really powerful legal tool that's been around for a long time.
And that tool is called substantive due process. I know it's a bit of a legalistic mouthful, but the idea is actually pretty simple. It's the principle that the Constitution's promise of liberty means there are just certain fundamental rights, certain things the government cannot do, even if those rights aren't spelled out word for word in the text. Here's a super simple way to think about it. Procedural due process is all about the how. Did the government follow the right steps? Did you get a fair hearing? Substantive due process, on the other hand, is about the what. Is the government even allowed to make this law in the first place, or does it violate a fundamental freedom? It's a total prohibition. And this old doctrine, as we'll call it, has been huge. I mean, it's the legal backbone for some of our most personal and fundamental rights. The right to make decisions about your family, your marriage, your body, your privacy. For a long, long time, it acted like a shield, protecting individual people from the power of the state. And this is where we get to the absolute heart of Litman's academic argument. She says that while the court has been busy chipping away at that old shield, it's been secretly forging a new legal doctrine, one that works a lot more like a sword aimed right at the government itself. So according to Litman, the court isn't just getting rid of this idea of substantive due process. No, it's something way more subtle. It's transforming it, twisting it into something completely different, which she calls the new substantive due process. And right here, you can see the pivot perfectly. The old doctrine was a shield for people, protecting individual rights like privacy from government overreach. But this new doctrine, Litman argues it's being used to protect a very vague, abstract idea of liberty, and then using that idea as a weapon to attack and reshape the very structure of government agencies. So you're probably wondering, okay, how on earth did they justify that? Well, Litman has a name for the specific kind of legal logic she sees the court using. She calls it structural reasoning squared. Let's break down exactly what she means by that. She says it's basically a three-step formula. First, the court takes a broad, unwritten idea from the Constitution's structure, something like separation of powers. Step 2, it decides that the one and only purpose of that principle is to protect liberty. And then the final step, the court just creates brand new, specific legal rules based on its own definition of what liberty needs.
And you can really see this shift in the real world when you look at cases about whether the president can fire the heads of federal agencies. The old question used to be a practical one. Does this rule get in the way of the president's ability to run the executive branch? But the new question, Litman says, is so much bigger and more abstract. Is the very design of this agency a threat to liberty?
See the difference?
Okay, so let's tie this all together. How does this wonky legal theory about structural reasoning squared connect back to the whole bad vibes thing we started with? This is where Litman brings it all home and talks about the role of the public. Here's the crucial link. This new liberty doctrine, this abstract legal tool, becomes this sophisticated, high-powered engine. And that engine, in Litman's analysis, is what's driving the entire agenda of grievance, fringe theories, and yes, bad vibes. It's the legal justification for a political project.
And this is a really critical point she makes. None of this happened by accident. The court didn't just drift in this direction. She argues point blank that the reason the court looks and acts the way it does is because there was a dedicated, long-term political movement that fought for decades to make it this way.
So what's the takeaway from all this? For Litman, if the court is the result of an organized political movement, then the only way to change its direction is with, well, an organized political movement. Her call to action is essentially a call back to the basics of civic engagement.
And that really leaves us with a pretty big question to think about. In a time when a lot of us are skeptical of our institutions, for all sorts of reasons, what does it truly mean? And what does it actually take to be an informed, engaged citizen today?